like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, here to discuss the Idaho 4 case. Now, in this video, I've got you two coming today, probably three. One of them, though, is going to be long and very boring, so that'll be the third one, but it'll be all the reference information that I have for the second one. Put a lot of work into the second one this morning. But before I do that, I wanted to go over new court docs. And we'll go over what has come out, point out a couple of things, and then I'll give you my opinion on what I'm seeing so far as it relates to Hippler on these things. So not going to hold you too long on this one. We're going to jump right into it. Okay, the first one is this amended order extending deadlines to file the motions in limine and resetting hearing. And if y'all remember, I did a video the other day where I was going through the initial order. And as I went through, I went, February 24th is the new deadline, responses by March 17th. And then it said any replies would be March 17th. And I went, whoa, what's going on? And then we went back to the original one and they asked for the 24th. But he had put the 17th and the 17th. Well, I'll be darned if today he didn't, or yesterday, or the 31st, he reissued it, actually extending the deadline for the replies out to March 24th like it was supposed to be. So it's amazing. I mean, we're able to go through and catch this stuff just like the court clerk is now. And by looking at it that way, putting it on our timeline, we knew it didn't make sense, and it didn't make sense to them either. So they have adjusted that so that all that should be fluent now. They have enough time to respond or reply to the responses. So I thought that was interesting. We caught it before they did. All right, now that's the first doc. And then we have this one. This is a order unsealing stipulated motion for sealed protective order and the sealed protective order. And it says, previously the court sealed the following filings in this case at the request of the parties. Stipulated motion for sealed protective order, filed on January 13th, 2025, and sealed protected order filed January 15th, 2025. After reviewing the matter with the parties, the court could find no compelling basis to maintain these documents as sealed filings. So, like we heard the judge say in the hearing with the media personnel, he said that there was way too much sealing going on in this case, and that going forward, the parties better provide a good reason for it to be sealed, and he better find good reason for it to be sealed, or he's going to find it. He's going to make sure it's not sealed. He's going to get it out there to the public. But it's interesting to me that his first decision on what's going to be sealed and not sealed was this protective order that he issued on January 15th. And the one that he's going to unseal for fairness actually prejudices the defense, not the state. So that kind of tells me a little bit of something about Judge Hippler right here. Because what did he unseal? Well, let's take a look. He unsealed the protective order. And what does it contain? Pursuant to Idaho Rule of Criminal Procedure 17, it's hereby ordered as follows. That this protective order shall govern the designation, disclosure, and use of medical and mental health records of the defendant and his family members disclosed to the state by the defense, In this protective order, the term protected information shall mean the medical and mental health records of the defendant and his family members disclosed by the defense outlined in Exhibit A to their first supplemental response to discovery. Access shall be limited to direct review by the prosecuting attorneys assigned to this case, and any further dissemination of the reference protected information shall be prohibited, other than to the extent necessary for the prosecuting attorneys to prepare for court proceedings, including hearings, trial, sentencing, further stipulation of the parties, or order of the court. The reference protected information shall not be talked about. Any specifics given during court proceedings, including hearings, trial, and sentencing, unless specifically agreed upon by the parties or permitted by the court. The prosecuting attorneys shall not produce any of the protected information to any unauthorized person. It shall be the duty and responsibility of the assigned prosecuting attorneys to ensure that the documents or the things contain protected information subject to their control shall at all times be kept in safe and secure fashion to ensure that such information is not disclosed to or made accessible to persons other than those specifically authorized to review protected information under this protective order. The assigned prosecuting attorney shall be directly responsible to the court for fulfilling this responsibility. The inadvertent or unintended disclosure, including those persons authorized to view the information of protected information, shall not be deemed a waiver in whole or in part of a subsequent claim of protection under this protective order, either as to the specific information disclosed or as to any other such information, provided that the inadvertent or unintended disclosure is promptly identified by the assigned prosecuting attorneys and notice of the claim of protection is given to the defense. Upon the final determination of this action, whether by settlement, dismissal, or disposition, the provisions of the protective order shall continue to be binding upon all persons or entities who are subject to the terms hereof. And it said, and the court shall retain jurisdiction for enforcing this order, but the judge, Stephen J. Hippler, drew a line through that and put his initials. So that means he does not want to retain jurisdiction for enforcing the order after the proceedings. The defense and prosecuting attorneys may request modification of this protective order upon showing of good cause. This protective order is sealed to protect the privacy of the information. The information subject to this protective order is confidential in nature and not appropriate for public disclosure at this time. Okay, so let me tell you why this is such a big deal, okay? Because he made all of this available for everybody to see. And what does it say? Well, it says there's this protected information that nobody gets to see, right? But in the very beginning, it talks about what the protective information consists of. And it's the disclosure and use of medical and mental health records of the defendant and his family members that are disclosed to the state by the defense. Now, why does the defendant and family members' mental health records and medical health records have to be disclosed to the state? Does it affect is Bryan Kohberger guilty of the crime portion of the hearing or the trial or the case? No. You see, if they were to find Bryan Kohberger guilty, then in the mitigation period, when they're determining sentencing, that is when the defendant would produce the information related to mental health, medical records of Kohberger and his family. So this would have absolutely nothing to do with the guilty or innocent phase of this entire case. But now, because Judge Hippler made this available, you can bet that idiots out there, guilters, and even the ridiculous mainstream media are going to take this little piece of information and they're going to disseminate it out there based on their, possible opinions, their subjective opinions. And what are they going to say? Oh, well, God, Kohberger's obviously, got a record of being crazy. And his family does too. It's his whole family full of crazies. No wonder this happened. That's the kind of crap that'll get put out there by this. And I have to think that the judge would know that. So in his effort to make everything available to the public and not sealing everything going forward unless there's good cause, we can see what he means by that. He means he's going to put the defense and all of its stuff on Front Street, and I haven't seen him unseal crap as it relates to the prosecution. So I got my eyes on you, Hippler. So in my humble opinion, you can start to read between the lines on crap like that. And I'm not liking what I'm reading between those lines, but I wanted to get that one out to you because I always want to keep you updated on all of the information that's coming out in those court docs. But I have another video coming to you pretty soon after this one, and we're going to get into some serious subjects on that one. And I've put a little bit of effort into it for you so that I can get you some really good, accurate information. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti's out.
Fly away. It's the first time